Unit 3, Part 3. Let's carry on. So, the management of a medical scheme. Section 29, subsection 1 of the Act requires for provision to be made in the scheme rules for the following. A. The appointment or election of a board of trustees consisting of persons who are fit and proper. Very important. Persons who are fit and proper. Always. People must be fit and proper to manage the business contemplated by the medical scheme. The appointment of a principal officer by the board of trustees who is a, once again, fit and proper person to hold such office. And then C, the appointment or the removal from office, the powers and the remuneration of officers of a medical scheme. Boards of trustees govern medical schemes. In Section 1, subsection 1 of the Act, a board of trustees is defined as, basically this is the definition. It is the board of trustees charged with the managing of the affairs of a medical scheme. So the board of trustees must manage the affairs of a medical scheme and which has been elected or appointed under its rules to do the job or to do so. The structure of the board. According to Section 57, subsection 2 of the Act, at least 50%, and we said this before as well, at least 50% of the members of the board shall be elected amongst the members of the scheme. So 50% of the members of the board must be members of the medical scheme. The Medical Schemes Amendment Bill of 1998, which is yet to be passed in law. So there's an amendment bill that needs to still be passed in law. But that provides that the remaining members must be appointed in terms of the rules of the medical schemes. In the case if it's a restricted membership scheme, like for BankMed, or should be appointed by the elected members in the case of an open medical scheme. You see, so the Board of Trustees of BankMed medical scheme must be 50% of the BankMed staff. The bank staff must be on that medical scheme. And in the case of an open scheme, 50% of any members of that medical scheme. In appointing the board by way of elections or otherwise, it is critical to ensure that the proper processes are followed to avoid nepotism, favoritism, corruption, patronage, and similar problems. So it must be open and fair and transparent. If processes are not transparent and fair, they will undermine the credibility and capacity of the board in fulfilling its functions. And that means that the board of trustees might not do their job properly, and that can sink the whole medical scheme. Ideally, people should be appointed or elected based on merit and their ability to make a real contribution to the successful management of the scheme's affairs. In acting as trustees, they must be able to be objective and think only of the best interests of the scheme and its members. So when you look at the structure of the board, the trustees are entrusted with the overall governance and strategic management of the scheme. They are responsible for ensuring that the scheme's affairs are properly managed, that it remains solvent and can meet its legal obligations to its members. The Act requires trustees and the principal officer to be fit and proper persons. If a trustee or the principal officer is in a relationship which will regularly and probably place him or her in a conflict of interest situation as a trustee, then such a person is not fit and proper to hold office. If you look at the size of the board, according to the King report, every board should consider whether or not its size its diversity and demographics make it effective or not. In the case of medical schemes, where a large proportion of the Board of Trustees is elected, this may not always be possible for the appointment of the board. However, the scheme rules, which can be amended by the current Board of Trustees with the approval of the Registrar of Medical Schemes, do have a role to play in the composition of the board. For instance, Rule 18, subsection 1 of the Model of Rules stated as follows under the heading of governance. The affairs of the scheme must be managed according to these rules by a board consisting of at least X amount of persons who are fit and proper to be trustees. The number of trustees is not specified for the simple reason that it may vary from one scheme to another scheme. The size of the Board of Trustees is, however, important. If the Board of Trustees is too large, if there are too many people, there is some negative things that can happen. For one, it may be more difficult to obtain a quorum for meetings because not everybody can be at the same date or time because they've got other things going. Proceedings are likely to be slower because more people have to be involved in taking of decision. So decision making will take longer. If trustees have to travel and stay overnight in order to attend meetings, then a large number of trustees can become expensive for the scheme because they have to pay for everybody's travel and accommodation and food, etc. So it can be pricey, costly. Rapid communication for the purpose of obtaining the views of trustees on issues outside of the board meeting can become difficult. Yeah, not really. We as trustees in our complex, one of our trustees sits overseas, but we're on a WhatsApp group and email. If one of the trustees send me something now or after this video in my break, I'll have a look on my phone. I see there's a WhatsApp, I read the issue, I said yes or no. I'm in, I'm out, I agree, I not agree, whatever. And the guy overseas will get it, he'll also respond within 5 minutes. Whoever trustee put it on there, he's got our backing or not, or we discuss it quickly. Or with emails as well. So it's not a problem anymore. I don't think so. But yeah, if they don't communicate by internet or by WhatsApp, if they don't accept that, yeah, then it can be a problem. It depends on how you do the things. And then the last one, people are more likely to form subgroupings within the board that act as independent individuals, each exercising his own objective judgment and expertise, his or her own judgment and expertise. Okay, the board of trustees is too small. What do we do then? So yeah, the range of expertise and experience necessary to manage the affairs of the scheme properly may be limited. If you are too few trustees, yes, it might be a problem because you don't have so much experience or expertise amongst the few of you. If there are more people, there's more expertise or better chances and experience amongst everyone. The risk of the domination of the board by a single powerful individual who does not necessarily always know what is best for the scheme is increased. That person is very dominant, strong character, strong personality, doesn't know what is best for the scheme and is making the wrong choices, and he can influence the other two or three to follow his way, which is not good for the scheme necessarily. The ability to ensure continuity between incoming and outgoing trustees is limited. The loss of one or two board members due to ill health or other mishap could seriously impact on the scheme. Yes, if you're 3 or 4 trustees and now 2 has got ill health and now suddenly they cannot attend the meetings and you're just stuck with the other 2. And then one say yes and one say no, and what then? That can be a problem. The introduction of new ideas and innovation in the affairs of the scheme could be stifled. Yes, the more the merrier. The more people you've got, the more brains you've got that you can put together to think of new ideas. The fewer you are, the fewer brains together, the fewer ideas. And succession planning becomes difficult. So the specific duties of the Board of Trustees are found in Section 57 of the Act and can be summarized in the table below. Number 1, appoint a principal officer who can tell me? Yes, fit and proper, always, as you know by now. People, you see what it helps to repeat. You automatically know it. A person to hold such office and shall within 30 days, not 15 or 20 or 40, within 30 days, within a month of such an appointment, give notice thereof in writing to the registrar. So you must inform him so that he can know who's the new principal officer of that medical scheme. Ensure that proper registers, books and records of all operations of the medical scheme are kept and that proper minutes are kept of all resolutions passed by the Board of the Trustees. Ensure that proper control systems are employed by or on behalf of the medical scheme. Ensure that adequate and appropriate information is communicated to the members regarding their rights, the members' rights, their benefits, their contributions, and duties in terms of the rules of the medical scheme. Take all reasonable steps to ensure that contributions are paid timeously to the medical scheme in accordance with this Act and its rules. So, and then take out and maintain an appropriate level of professional indemnity insurance and fidelity guarantee insurance. Obtain expert advice on legal matters. So if nobody, there's an attorney, you're not sure, get expert advice on legal matters, all accounting matters, or any other business matters. And that is the same thing that we trustees now complex to. There's not an accountant or a legal person, but then we reach out to our a legal person, ask them, or accounting person, etc., as required, or any other matter of which the members of the Board of Trustees may lack sufficient expertise. Yes, if we've got building projects, not one of our trustees is a builder, then we get a builder to come and sit with us. We give him the opportunity. We tell the builder, we want to build this and we need quotation. Come and sit with us and give us your side of the story, your expertise, and let's discuss this for the way going forward. 8, ensure that the rules, the operation and administration of the medical scheme comply with the provisions of this Act and all other applicable laws. And 9, take all reasonable steps to protect the confidentiality of medical records concerning any member state of health. So you know, those information is confidential and must be kept confidential. So still at the duties of the Board of the Trustees, the Act also stipulates that the Board of Trustees must A, take all reasonable steps to ensure that the interest of beneficiaries in terms of the rules of the medical scheme and the provisions of the Act are protected at all times. B, act with due care, diligence, skill, and good faith. C, take all reasonable steps to avoid conflicts of interest. And D, act with impartiality in respect of all beneficiaries. The moral rules stipulate that trustees serve a term of 3 years. So as a trustee in a medical scheme, you can serve a term of 3 years. The Medical Schemes Amendment Bill recommends the renewal of an additional 3 years term Oops, sorry for my beautiful art there. Provided a person shall not serve as a trustee for more than a total of 6 years in any one medical scheme. So you can do a term of 3 years, then you can renew it for another 3 years. That will give you 3 plus 3 is 6 in total. That is the maximum you can serve in one medical scheme. This extended period affords a trustee the time to develop skills in scheme governance, but would avoid a situation where trustees entrench individual power bases, in the scheme. You can also call it power bosses if you want to, with potential detriment to the interest of beneficiaries. They say if you are too long in the trustees, you become like a boss. And this forms a basis of being in power. And that can be an issue. That's why you cannot stay there for too long. Appointment of a principal officer. The Act provides guidance on the appointment of a principal officer. In this regard, it stipulates in Section 57, subsection 7 of the Act that a person shall not be a principal officer of a medical scheme if that person is A, if you're any one of these, an employee, a director or officer, a consultant or a contractor of the administrator of the medical scheme concerned, or of the holding company, subsidiary, joint venture, or associate of that administrator, or if you are number B, a broker, then you are not allowed to be a principal officer of a medical scheme. These fiduciary duties require of him or her to A, to act in good faith and to promote the employer's business over the employee's own. B, to serve his or her employer's interest honestly and faithfully. C, not to work against the interest of an employer or to secure secret profits or commissions. The duties of a principal officer and his or her staff are not specifically provided for in the Act or in the regulations to the Act. This shortcoming is addressed in the Medical Schemes Amendment Bill of 1998, which is yet to be passed into law. From the wording of the Act, it is clear that the person who is appointed as the principal officer must be fit and proper, as we all know, to hold the office, and similarly to a trustee must not occupy a position that puts him or her in a position of conflict of interest. So now we look at the important duties of the principal officer. The importance of the principal officer to a scheme should not be underestimated. He or she is responsible for ensuring that the instructions of the board are carried out and that problems regarding the administration of the scheme and its affairs are timeously brought to the board's attention. A principal officer would be the most senior employee of a medical scheme in most instances, and he or she owes a fiduciary duty to the scheme, similar to that of an employee to his or her employer. So in the model rule, the duties of a principal officer and his or her staff are listed as follows. Number 1, the staff of the scheme must ensure the confidentiality of all information regarding its members. It's very important. They must keep the members' information confidential. 2, the principal officer is the executive officer of the scheme, and as such shall ensure the following: that he or she acts in the best interest of the members of the scheme at all times, not negotiable. 2, the decisions and instructions of the board are executed without any unnecessary delay. 3. Where necessary, there is proper and appropriate communication between the scheme and those parties affected by the decisions and instructions of the board. 4. That he or she keeps the board sufficiently and timeously informed of the affairs of the scheme concerning any matter relating to the duties of the board as stated in section 57 subsection 4 of the Act. 5. That he or she keeps the board sufficiently and timeously informed concerning the affairs of the scheme to enable the board to comply with the provisions of section 57 subsection 6 of the Act. 6. That he or she does not make any decisions concerning the affairs of the scheme without prior authorization by the board, and that he or she at all times observes the authority of the board in its governance of the scheme. In other words, doesn't matter who they are, what they do. You need prior authorization by the board at all times before you can make any decision concerning the affairs of the scheme. All right, up front. Number 3, the principal officer shall be the accounting officer of the scheme charged with the collection of and accounting for all money received and payments authorized by and made on behalf of the scheme. 4. The principal officer shall ensure the carrying out of all of his or her duties as are necessary for the proper execution of the business of the scheme. He or she shall attend all the meetings of the board and any other duly appointed committee where his or her attendance may be required and ensure proper recording of the proceedings of all meetings. The principal officer shall be responsible for the supervision of the staff employed by the scheme unless the board decides otherwise. The principal officer shall keep full, proper records of all money received and expenses incurred by, and of all assets, liabilities, and financial transactions of the scheme. The principal officer shall be prepared annual financial statements and shall ensure compliance with all statutory requirements pertaining to it. So who cannot be a member of a medical scheme? A person who is already a member of one medical scheme is legally prohibited from becoming a member of another scheme unless, and there is unless your membership of the first scheme has been terminated. That's according to section 28. So if you want to move over to another scheme, you cancel this one, terminate it, and then you start on the other one. But they must go hand in hand. So if this one ends on the 31st of January, the other one must start the next day on the 1st of February. This means that the membership of the second scheme will not be legally valid as long as the member remains a member of the first scheme. You cannot belong to two schemes. It's either one or the other one, but not two. Therefore, the person must resign from membership of the first scheme in order to become a member of the second scheme. That's the only way they will allow you. Should the second scheme unknowingly pay any of the members' claims, and this happened in the past, the schemes don't know. So a guy is on Discovery Health and on Momentum Health and somewhere on Liberty Health as well, or whatever. then they pay. And then they claim. They send the bills they try to make money. They send the bill to Discovery and to Momentum and Liberty. They somehow work things out. They try to commit fraud. So should the second scheme unknowingly pay any of the members' claims, it would be entitled to recover the money from the member as his or her membership of the second scheme is not legal and the medical scheme cannot pay benefits to non-members. So if you belong to another medical scheme, your second membership is not legal, therefore they cannot pay out for non-legal members, and therefore they can claim the money back. They will take you to court and they will sue you. Section 21, subsection 1R of the Act also states that the dependents of a member are entitled to participate in the same benefit option as the member. So your members can get your dependents can get the same benefits as the main members. All right. That's the end of this part. See you in the next one.